When you have a Mozart and then you start trying to come up with newfangled ways to generate music, you're probably not going to do as well as Mozart did. And we had a group of Mozarts that gave us our Constitution and our Declaration.
John, how's the Constitution doing these days?
Dead man walking. Look, the Constitution is under attack from so many areas. People ask me why I'm so busy these days. I say we only get involved in cases where the Constitution is being ignored. It's become a full-time job. Look, there are a couple of propositions. The very nature and purpose of government has changed. We no longer have consensus about that. And that means we no longer have a consensus that government ought to be limited. Mm-hmm. Some people think that government only does good, and therefore we need more of it. And in fact, if we can have it all-encompassing to take care of us from cradle to grave, that would be so much more good that that would be utopia on earth, right? And they forget that in our human nature, you give people power, they tend to abuse it for their own purposes rather than the common good. And that's why we have a limited government. And that basic fight, whether we're going to continue to have a limited government or we're going to have an omnipotent government, is what we're in now. And an omnipotent government can't exist with a constitution that sets out a limited government structure.
Mm-hmm. Well, by unlimited government, you know, semantics is all, or maybe not all, but almost all. The left would say, we mean the living Constitution, not the dead one, the 18th century one that you're trying to revive. But that's the dead man, maybe not walking. What do we think of the living Constitution?
Well, I don't know what it is. They say that the Constitution evolves to keep up with current times. I ask law professors that come up with these theories about how it's evolved, and I say, well, tell me what the new rule is, because it seems ever evolving. And if it evolves in the direction they like, they think it's good. If it starts evolving in the direction they don't like, or back my direction, they think that's bad, and they say, well, you can't do that.
That's not evolution.
And that's right. Jefferson had a great line here. He recognizes that a current legislature can never bind a future legislature. Mm-hmm. But when they passed the Jefferson's Statute on Religious Freedom, he says the truths we are identifying here are immutable. And so any deviation from them would not be progress.
Right.
And if the founders actually achieved some immutable truths that they built into the Constitution, the notion that limited government is the best protective of rights, what have you, that when we deviate from it, it's not progress, but it infringes the rights that the constitutional structure was designed to protect.
Right. This is like Coolidge's formulation in his famous speech on the Declaration, right? There's no progress beyond limited government, constitutional government, the equality of man. You can only go backwards, not forwards from certain truths.
When you have a Mozart and then you start trying to come up with newfangled ways to generate music, you're probably not going to do as well as Mozart did. And we had a group of Mozarts that gave us our Constitution and our Declaration. They really were giants, intellectual giants. There were a unique set of circumstances. They had the philosophical foundations from their studies, and they had the practical foundations from their experiments in self-government in the states leading up to the Revolution. That was kind of a unique alignment of the stars that gave us a great set of governing principles.
They had a living education. In tyranny, which tends to concentrate the mind.
That's right.
But would a conscientious liberal would not admit to your distinction, I think, because he would say, look, we're about rights too. We're about protecting rights. We're about protecting individual rights. It's just that rights, like society, are evolving things. And so you want to protect a basket of old rights, and we want to protect the most necessary new rights. Are they right in that characterization?
No, but that means, since I've criticized Justice Scalia earlier, let me praise him. He said, our newfangled notion of rights tends to expand rights for some at the expense of others. And so I'll give you an example. Somebody told me the other day, he says, why shouldn't people have a right to health care? And I said, well, of course they should have a right to health care, but what you're seeking is the right to have somebody else pay for their health care, right? And that, of course, deprives somebody else of their natural right to the property, the fruits of their own labor, to provide something for somebody else. That's not rights, that's actually slavery when I can force somebody else to work for me. And the same could be true of all of the other newfangled rights, the right to housing, the right, all of these things that come out of Roosevelt's New Deal, right? These are the new rights. What we call positive rights actually deprive somebody else of their natural rights, by definition.
The second Bill of Rights.
The second Bill of Rights deprives people of their first Bill of Rights. And until we talk about it and recognize it in those terms, conservatism will not have a full answer to the living Constitution.
But wouldn't you say, I mean, is there a problem here? Because as you were arguing earlier, you have a duty to pay taxes to provide for courthouses and police forces and all kinds of things, which you may not agree with personally, and you may therefore regard such exactions as violations of your property rights. How would one distinguish that case from not paying taxes or paying taxes to provide a right to health care to other people as a kind of taking of your property against your will?
The one seeks to tax everybody to provide for the things, the public goods, for the common good. The other seeks to tax some to provide for the private welfare of others. And I think our Constitution's text actually addresses this. The power to tax and spend in our Constitution is to provide for the common defense and the general welfare. What Roosevelt and the New Deal did is turn that phrase general welfare, which meant national welfare. You could not tax one region of the country to pay for projects in another. If I wanted to expand the road in Santa Ana, California, then the people of Santa Ana should tax themselves to pay for their road, not be able to tax the folks in Rhode Island to pay for their road. General welfare. Roosevelt turned that, almost in a Linskyite turn of phrase, if you will, a little anachronistic, right? Welfare meant the provision of goods to individuals, not the general welfare, and therefore it was okay to take money from you to give to somebody else. Madison says that that's the very definition of tyranny, to take property from one to another. So we've turned the protections in the Constitution upside down in order to have this new notion of rights, positive rights that have come out.
So it's unconstitutional to take money from Peter and give it to Paul. But in providing health care, in providing a right to unemployment benefits, you couldn't defend those on the grounds that they have systemic effects, that they're good for society at large, they serve the common good even if they're not a classic public good?
Well, let's try and look at it the way the founders would have. Even if that were true, that would be true at the local and state governments, not at the national government. Because the danger of doing it at the national government is to create such an infrastructure on a nationwide scale, requires such an exercise of power by the central government that the risk is that it'll become tyrannical in a whole number of other areas. And I think we're seeing that play out. That the more government controls the things of daily life, which were supposed to occur regulated at the state or local level, the more power it has and the more it can abuse that power.
Now, which branch of government is currently most dangerous to the Constitution, would you say?
One of the great erroneous predictions of our founding generation was that the judiciary was the least dangerous branch, and it has become the most dangerous, both because it makes up rights and then it imposes them against the democratic process, but also because it has abdicated its role to serve as a check on the valid exercises of legislative power. And by abdicating that role, it has allowed the legislature to do whatever it wants. And legislatures are going to try and grab as much power as they can. The judiciary abdicating that role makes it most dangerous because it lets the legislature get away with it.
So was Hamilton in the Federalist Papers who pronounced that the judiciary was the least dangerous branch? Was he fibbing, or was he wrong? How did you understand him?
He wasn't wrong at the time. What he says is that they're the least dangerous branch because they have neither the power of the purse or the sword. Right. They don't make the law, they don't control the appropriations process, nor do they execute the law. They only sit in judgment. But in the last 50, 70 years, the court has actually increasingly started making the law and executing the law. They impose taxes as remedies for judicial disputes. They execute their own enforcement, and they have become what Montesquieu would describe as the very definition of tyranny, the consolidation of the legislative, the executive, and the judicial power all into one.
Well, two questions. That sounds also like the administrative side of the government. But secondly, hasn't the Congress and many presidents too, haven't the Congress and the presidents often invited the court to exercise such authority?
They have, and herein lies the problem. The McCain-Feingold campaign finance statute is a wonderful example. The authors of the statute on the floor of the Senate conceded that there were probably significant parts of it that were unconstitutional. But
don't let that stop you.
But they voted for it, because we've now accepted the view that even though they take the same oath, members of Congress don't have to decide constitutionality. That's the court's job. And then this bill gets to the desk of the president, who signs it with a signing statement that says, I think there are major portions of this that are unconstitutional, and yet he signed it. Washington thought that the only exercise of the veto power would be if they thought something was done unconstitutionally, and yet the president here signs it despite him thinking it's unconstitutional, because that's the court's job. And then what does the court do? It gets that, and it says, we are going to defer to the considered judgments of the Congress and the president about the constitutionality of this statute.
Right.
Right. So it's no wonder that the elective branches have deferred to the court, who in turn defers to them but gives them all the cover they needed to do their unconstitutional thing, because the court said it's now constitutional what we have done.
Well, now speaking of the administrative side of things and the tendency of modern bureaucracy to concentrate legislative, executive, and judicial powers in its own hands and to abuse its power, the Internal Revenue Service has lately become the object of public ire and public discussion, to say the least, because of the partisan application of its regulations to conservative groups and to Tea Party groups. Now, you happen to have run afoul of this personally. Say something about your experience and how you look at the legal situation now.
Sure, and one of the other hats I wear is I'm the chairman of the board of the National Organization for Marriage, which is kind of the leading umbrella group of fighting for traditional marriage around the country. And we weren't one of the groups that had our applications delayed. We actually had our donor lists, which are part of our mandatory tax returns, disclosed to our political opponents so that they could be harassed and discouraged from continuing the fight. That's a felony. It's a serious felony. This was one of the
that your political opponents could harass and discourage your financial supporters whose names had just been disclosed to them. Right.
That's right. Yeah. And remember, this is one of the charges of impeachment that had been drawn up against Richard Nixon for abuse of the IRS. At that time, the disclosure of tax returns was a misdemeanor, and in the wake of the Nixon abuse of the IRS, they made it a serious felony, 5 years in prison. But there's a broader thing going on here than the fight over marriage or the fight over Tea Party groups. As I said earlier, we've now got a fight between the very purpose of government. Is it going to become comprehensive, all omnipotent government, or limited? And increasingly, the levers of government are being used to weigh in on the fight for big government. They've become their own faction, their own interest group. And we see the IRS scandal, I think, most clearly in that light, that they are protecting the prerogatives of government to treat all the rest of us as subjects, not as, in fact, their sovereign authority.
And what recourse do citizens have then?
Well, the first recourse is, on the IRS things, there are statutory causes of action that one can fight out in the courts. If the courts end up siding with government on that, I fear that the recourse is going to be more revolutionary in nature. People are, I think, at their limit of tolerating government impositions in this way. When I testified in Congress on this IRS scandal, there was a woman who had founded a small Tea Party group down in Texas. And she gave a wonderful line. She says, I am not here as a serf begging my lords and masters for permission. You have lost your understanding of your proper role in our constitutional system. And I think that says it really well.